Okay.
Well, thank you for the summary. Thank you so much, sir. Again, we move to another Principal Assistant Registrar of the Federal Ministry of Industry, Trade and Investment. He is the head of acceptance unit of the Trademark Registry, a man who holds master's degree in various fields of IP. For the next 15 minutes, he will take us on the step-by-step of trademark registration procedures. Please welcome Barrister Ogunbanjo Temitope Adeniran. Barrister T, you have the floor.
Thank you very much, Pachi.
You're welcome, sir.
As you rightly introduced, my name is Ogunbanjo Temitope Adeniran, the head of the acceptance unit. Basically to take you through the process of filing your application for registration of trademark. And I would like to state here categorically that trademark is filed in 2 stages. The first stage is known as acknowledgement and acceptance level, which is the first one you may be able to work with, get your approval if you are proceeding to registration in NAFDAC. Those are the documents you need to move up to NAFDAC with. And the process here is first you have to, we have to main system of trademark application system in the registry. We have the online system, which you could sit at the comfort of your home, file your application, and the registry receive the application at the back end and process. We have the IPAS system, intellectual property automation system, which is called IPAS, and it's semi-auto in the sense that you still have to bring your physical papers to the registry and submit at the PGO. Then we process the application onward. And before I move further, I would like to state here that who can process a trademark registration? Before now, it used to be accreditation procedure, but we are going to deploy, we have even deployed a new system now, which allows everybody to come on board. You can sit at the comfort of your home, register yourself an accredited agent without any payment, then you have your password sent to your email, then you can now log on. In a short while, I'll be taking you through the step-by-step process of registration. I would like to give you the website for your registration. That's www.iponigeria.com. I don't know if you can see, it's written down here for you.
No, we can't. Don't worry. Secretariat, could you please type in that so that people can see it?
Okay, where is it?
Yes.
Yeah, message.
T, yeah, please continue.
No, I will. Okay. I think I'll have to do that later. Let me continue with my. So the first step to take is first to undertake what we call preliminary search. Officially, that costs 1,500. The essence of preliminary search is for you to know if the name is available for you to register. There are 2 issues to consider here. The name may be available and not registrable. Like my senior colleague have said, by virtue of Section 9 of the Trademark Act, you have what can be registered as trademark. By Section 11, we have what is stated there that cannot be registered as trademark. So if your mark is searched upon during preliminary and is said to be free, you need to find out if by virtue of Section 9 and Section 11 of the Trademark Act. If it is free, you move on to proceed with your registration. You log on to that www.iponigeria.com. Then for our new system, you need to first register. It's self-explanatory. If you log on to the WWC2 system, register first as a user, or if you are already registered, you will see a platform that will give you first, number 1, you see new trademark application. You just have to fill in the type of trademark. You have to state here what type of trademark you are registering. And in registering, we have what they call device. We have either with word and device or device alone. And I would like to state here, if you are registering a device alone, a device is a logo. The logo you have on your product is your device. The name is the trademark. The name of your product is the main trademark. So the device, if you are choosing a device, if you put a device in one color, if in black and white, automatically you are protected in every color. If you put a device and you specify it in particular color, maybe blue, red, you have restricted your registration to that particular color. It's always advisable if you are registering in black and white, you'll be protected in every shade of colors. Then if you move to the application, if you open the portal, you will see a system where you will be asked to fill in some form, trademark type, which you have to pick whether it's local or foreign. It's a foreign application if you are representing a firm from abroad, whose address is in outside the country. And I would like to state here, by virtue of the trademark regulation, a foreign applicant cannot file by itself. The service of an attorney in the country is mandatory. So the attorney will have to choose foreign. Then you move forward to the next line, which will give you a description of the application. You put in the title of the mark. If, for example, maybe the name of the mark is Yogo Milk and Device, you type in Yogo Milk and Device there, and all the line, you pick in the class. We have the classes in classes 1 to 34 for goods, class 35 to 45 for services. You have to determine what class you belong based on the product you are registering. Each class represents a particular
Barrister T, are you there? Hello? I think we are having a connectivity problem.
Yes, I think we're having a connection problem with, but let me chip in before he sorts that out. It is important from what Mr. Ogunbanjo has said that we should take note of the nature of use of marks, because it is the nature of the use that the trademark is going to be put to that determines which class or which number of classes falls. If you are in doubt about which class a particular product falls, please take time and seek the advice of the registrar. By the provisions of Section 4 of the Trademarks Act, the decision of the registrar on the issue of classification is final. So applicants are free to seek registrar's opinion or advice on classification. Now, another important point that he has mentioned also is the issue of acknowledgement and acceptance. Acknowledgement and acceptance are official response to an application when it is filed. The acceptance does not constitute the final registration of a mark, but it is an indication that an application has been received and it has been accepted by the office. And that means that the mark will subsequently be published, and then if there is no opposition, if opposition is overcome, then certificate of registration will be issued. And certificate of registration is the final proof of the right over a trademark. It is also equally important to take note of the fact that submission of bromides in color means that the trademark is restricted to the particular color that the applicant submits the bromides to the registry. For administrative purposes, and it is very important for lawyers to also advise clients clearly, if the bromide of the trademark that is sought to be registered is in black and white, it means for all intents and purposes, it is and it represents all colors. So it gives you more advantage if you file your application with bromides that is in black and white. But this depends on the client's instructions. Another point to take note of is you often hear lawyers saying that I have registered my trademark at Corporate Affairs Commission. No, what you have registered is the company's name. You need to have trademark, and the only place you obtain trademark registration is at the Trademarks Registry. Very important point to note, the Trademarks registration supersedes any company registration any person may have at the Corporate Affairs Commission. This has been clearly set out in the Companies and Allied Matters Act, which clearly states that where there is conflict between a trademark and a company's name, and the registration of trademarks will override the existence of the company. So it's very important that you protect your trademarks. One other important point that I have wanted to highlight initially is what are the fundamental functions of trademarks? There are four. One is the identification function. Trademarks function to identify goods. You know, when you are looking for pig milk, the moment you see the pig sign, the canoe, and the two men riding on that, that is pig milk. The next is that it also helps to distinguish between competing products. When you see a particular trademark that you are used to, you can distinguish it through the trademark, through that sign that qualifies it as a trademark from another similar product that is competing with the product that you seek to purchase. So it identifies, it distinguishes. Another function of the trademarks is the quality function. Because of the quality function of a particular trademark, you find customers making repeated purchase, repeated demands. This is due to that intrinsic value of the trademarks, which identifies the quality of the product that makes purchasers to repeat purchase. And then the last function is that of advertisement. When you get into a supermarket or into any shop, you quickly identify the product that you want to purchase by the mark, the sign that it carries, which is the trademark. These are the four main important functions of trademarks. Kachi, can we check whether Tokwe is still there? Hello?
I'm back online. Thank you, sir.
Okay, please, can you continue from where you stopped?
Okay. Yeah, thank you. I was saying, I just put in the website on the screen now. If you log in, it's a simple website. It's self-explanatory. Just follow the procedure. You will be prompted on every step. Then that one will take you through the first step. The second step is after the mark has been examined by the examiners, they will have to go through two separate ways. If the mark is examined, the examiner will determine whether the mark is approved. If the mark is approved, acceptance letter will be issued to the applicant. In the new system we have now, the acceptance letter will move straight to your platform based on the email address you submitted when you are filling your application. But if the mark is refused by the examiner, you receive what is called refusal letter, which means in that case, as an agent for an applicant, you may go by way of appeal to overturn the refusal. The registrar has the discretion and power to overturn appeal if you make give a good cogent reasons why the refusal should be overturned. But in the case where the application is accepted, you will receive an acceptance letter, then the application automatically proceeds to what we call publication stage. This is the procedure where the general public will be notified of your intention to register a particular kind of mark, device, and anyone who has any objection can come forward by way of opposition to the registry within 60 days of the publication of that journal to raise their objection why that mark should not be given to the applicant. This take a kind of quasi-judicial procedure in the registry, and a decision of the tribunal is subject to appeal at the Federal High Court. But if the decision of the tribunal is in favor of the applicant, the registrar will be, the applicant can go forward and proceed to apply for registration of the mark by paying the prescribed fee for the certificate, and certificate will be issued. And this is basically the procedure for registration. And certificate is issued for the first 7 years and renewable every 14 years. Trademark registration is perpetual for as long as you continue to renew your application. And again, date of your application starts from the date you file the application first. That is basically the process for registration. Thank you.
Yes, thank you very much, Tope, for that. Again, Kachi, please permit me to just add a few notes on 1 or 2 issues from what Mr. Ogunbanjo has explained. One is the issue of examination. The issue of examination of trademarks are in 2 forms. There is the formal examination and there is the substantive examination. The formal examination, examiners will look at the form of the application itself. What is the name of the company, the address of the company, telephone number or email, the classification and what have you, all are formally in order. And once the check is okay, then the examiner also examines substantively. Substantively here means looking at the provisions of the Act. Mr. Sadiq Yusuf has explained to you earlier on what are registrable trademarks, what are not registrable trademarks, what qualifies for marks to be refused or rejected by the examiner. All this will now come to play by the examiners. And the next issue is the mark may be accepted or may be refused. If it is accepted, it may then proceed, like I mentioned in my earlier intervention, in the operation of section 19, the mark will be, the mark will be published in a journal. But also there may be conditional acceptance. That is, the mark is accepted conditionally subject to the performance of certain actions. In certain cases, the registrar may publish a mark without acceptance, meaning that the mark will now be subjected to the formal procedure of opposition process before it is granted acceptance or registration. What happens if the mark is refused? If the mark is refused, now the dual function again of the registrar comes into play. Mr. Sadiq Yusuf has again mentioned that the registrar performs a quasi-judicial function, and also he performs an administrative function. You have the right of appeal to the refusal to the registrar, and the registrar can upturn the refusal and grant acceptance, or he can maintain the refusal and, of course, subject to appeal to the court from that position. Now, however, when it is an opposition matter, the process of opposition as provided under section 20 and in regulation 50 to 54 will follow. The notice of opposition filed within 2 months from date of publication, counter statement within 1 month, statutory declaration and any reply thereof. Then the parties will appear before the Trademarks Tribunal, where the registrar sits and, of course, pass his ruling. Rulings from the registrar are also appealable to the Federal High Court. I will stop here in order to provide opportunities for questions. Thank you very much, Toke, for your own contribution. Kachi, over to you.